Okay. All right. Okay. Thank you for coming, and at this time we'll open our meeting and ask Representative Deffenbaugh if he will run us a word of prayer, please.
Pray. Our Father, we do thank you for the opportunity of meeting today. We know that the issues that are before us is important to all the people in the state, and we pray that we might have a servant's heart, and as we look at it, we might ask for your wisdom and guidance in deciding. For we pray this in Christ's name. Amen.
Amen. Thank you, Representative. We have a sign-up sheet for anyone wishing to speak. I think on the podium to your right, but if you wish to address the committee today, please sign up. And for information, today's meeting will be just to gather information and to hear the presentments. There'll be no action taken as far as action from the committee on this. So with that being said, this time we recognize Governor's floor leader, Mr. Nummer, who is presenting to us House Bill 952. Mr. Nummer.
Well, thank you, Mr. Chairman, members of the committee, and those in attendance. I bring before you for your consideration and questions today House Bill 952. This bill has been titled the Georgia Professional Regulation Reform Act. I know this bill, before we get into the mechanics of it, has spurred a lot of question and conversation out in the halls and amongst members, and I think that's a great testament why we have the process we do and why we're in here today to try to get through some of the concerns that this bill may have. This bill is a result of, as many know, a case that was brought up in North Carolina with the Dentistry Board, to where the Dental Board of North Carolina was trying to shut down some teeth whitening clinics, saying that they didn't recognize them, and that was then challenged by those teeth whitening clinics to the state, and that went on into a Supreme Court hearing, and the Supreme Court ruled in favor of the whitening clinics. The short of it, this bill shifts all occupational licensing boards to oversight under an appointee of the governor, whoever he or she may deem that person to have the oversight authority. That appointee must, by language of the opinion, have the authority to overrule, modify actions taken by any board. The proposed shift saves the ability of experts in the relevant field to suggest and implement proper regulations, but brings the board within the gamut of state action immunity and also places a restriction on unnecessary restrictive regulation. Now, there's been several that have come. I've talked to a couple on the committee, Mr. Chairman. Talked to several out in the audience today, and I don't know how much detail you want me to go in. The bill is very self-explanatory. The summary of it that I just shared, it basically gives all licensing boards in the state of Georgia an oversight of the governor or his or her appointee. I've talked to several that have expressed support, and I've talked to several that have expressed concern. I've had no one tell me that we don't need to do something with the case that is a result out of North Carolina challenge, and looking at Georgia being potential for going into a litigating posture and to try to keep us out of the court systems, thus saving taxpayer money, but also not yielding too much power into one authority. There's a fine line we have to walk, and it's our responsibility, I think, as this body to address that concern that's in front of us. So the Attorney General's office, the Secretary of State's office, and the Governor's office joined together, and I came in my vast wisdom of legal background and tried to clarify some of the things that they were wanting to do. And what we have before us is House Bill 952. If you'll look through the bill over in on page 2, beginning on line 31, this chapter shall be known and may be cited as the Georgia Professional Regulation Reform Act. It is just what it says it does. It gives us some bit of reform and safety net for many of our boards in this state going into litigation on the Supreme Court level. Mr. Chairman, I'm sure everybody's read the bill. I'll touch through it at line 35. It says the governor means the governor of the state of Georgia or his or her designee. Professional licensing board means any board, bureau, commission, or other agency of the executive branch of state government which is created for the purpose of licensing or otherwise regulating, controlling any profession, business, or trade, including all boards, bureaus, commissions, or other agencies established pursuant to this title. If you come down to line 47, it says that the governor shall have the authority, and this is his or her designee, shall have the authority and duty to actively supervise the professional licensing board of the state to ensure that their actions are consistent with clearly articulated state policy, and shall therefore have the authority and duty to, and then you get into the meat of what the actions are: review in writing, approve, veto any rule before it is filed in the office of the Secretary of State. It goes on down and just clarifies what that means and how that will take place. Over in on page 3, it talks about the challenge and the appeal on line 60 and line 61. These reviews must be submitted by a professional licensing board for review by the governor. And any of these rules that are put into law, promulgating them, any regulation or executive orders necessary to effectuate the provisions of this chapter, including regulations or orders relating to the process, procedures, timelines that will govern any appeal or submission filed in accordance with the code section. All of that in a nutshell is a lot of legal language to get us to a point to where we're saying, again, out of the opinion of the Attorney General, the Secretary of State, and the Governor's Office and his General Counsel, that the state of Georgia is in a posture to try to do something along with a lot of our sister states in the nation, hinging on the heels of the North Carolina decision in Supreme Court. We're here to listen. I appreciate the opportunity to come and present this bill to you, Mr. Chairman. I'm sure there's going to be some question. I see that there are some signed up on this testimony sheet, Mr. Chairman. However you want to handle it, I'm here for you.
All right. We're going to, this time, Representative, entertain questions from our committee members. Number 3, Representative Dudgeon.
Thank you, Mr. Chairman. Thank you, Representative Nimmer. I followed this court case, interestingly enough, myself, so I think it was a good decision, actually. I don't have a problem in theory with what the bill is doing, but I think it should be step one. I think part of the message of the court is maybe there's too much power and too much regulation in general. And I'd like to see, other than just having the governor or somebody doing this veto power, I think the General Assembly should study whether we have too many of these boards and whether there's some we can actually roll back. I'm sure there are some that are really good, but we have a long list of these things. And I think when you start doing things like regulating teeth whitening and stuff like that, you've kind of jumped the shark, so to speak. So I would like to see, for my opinion, is, again, I don't have a structural problem with this, but I think the message is bigger than just this, that we need some sort of veto person. That I think the General Assembly needs to look at whether we need to roll back some of this and actually do. It says Regulation Reform Act. I'd like to see some reform by removing some regulations. So that's one man's opinion who won't be here next year. Thank you.
Well, your opinion is well respected and well taken, and Representative Dudgeon, that opinion has come several times, and for the sake of time and trying to get some safety net in place before we go through and study all the boards, I think there's, Mr. Harper May can tell me, I think there's more than 40 boards in the state of Georgia. Chuck's here from the Secretary of State's office, but that has been one of the primary concerns to get back to. Do we have too many regulatory boards? Yeah,
I just don't want us to paper over this by saying, okay, we come in compliance with the Supreme Court, and then we forget about it. Do you know what I'm saying?
I don't think that's going to be the case, Representative Dudgeon. I think that's been a concern that I've heard pretty consistently, that is this the start for us to get a safety net and then dive in and look further at how much regulatory power we have on some of our businesses. So, thank you.
Thank you, Representative Dudgeon. Representative Harden.
Thank you, Mr. Chairman. And Chairman Nimmer, I appreciate you bringing this. But,
I appreciate you calling me Chairman Nimmer. I've never heard that before. Thank you.
Floor leader, excuse me, sir.
You did.
But I do
They call a lot of other
have
things,
some
but-
real serious problems with this and the way it's written. And I'd like to, I have served on a board before.
Okay.
And I do know that, of course, appointments are all made by the governor, and that they serve at the pleasure of the governor, basically. But the regulation has always been done basically through an assistant attorney general who meets with boards and advises them as to the legality of any item they're considering, whether it be a rule, regulation, or a punitive action. And then we've got the administrative court systems. So I don't know that we are in the same position that North Carolina was. I do believe that we've got active supervision currently over our boards, and I do believe that the anti-competitive conduct is consistent with clearly articulated state policy. Now, I think this whole problem could be solved by working on just a clearly articulated state policy. Another thing that really concerns me is this could turn out to be a major anti-jobs bill and a small business killer, basically, because what we're doing here now, and when I first saw it, I asked if we could not remove the governor, his or her designee, by putting a person in with this much power, because that designee is defined as the governor in this bill. So, and that person is not, I don't know whether they are under the stated, the state's Employment Act or whatever. We won't know that. And if not, that's really troubling to me. Right now, we have good oversight by the Attorney General. We have good oversight by the Secretary of State. We have good oversight. Actually, I think the legislature is basically the one that is designated to handle these board issues. So I've got a major problem there. And maybe, if we look at line 23, to ensure that the state's professional licensing board and board members are entitled to antitrust immunity. From my remembrance of the board, and it's a long time ago, maybe it's changed, but we were told as long as we followed the Attorney General's opinion on what we did, that we were immune. And I think this North Carolina case, they must not have had a lawyer or a state lawyer or Attorney General sitting in to advise them. If they did, then they should have been covered, because I think that gives our board members immunity. And this may also create a new super job in government, because this on line 47 we say the governor shall have the authority and duty to actively supervise all the professional licensing boards. You said, I believe we've got 40 licensing boards.
More than 40, yes.
And they probably, I don't know, do you have any idea how much of the state's population those licensing boards cover? The reason I ask is it does worry me about the jobs situation. All of these people are licensed as contractors, healthcare providers, and they are the small businessmen in all of our communities. And I've got a real concern about turning all of this power over to someone whom we define as the governor but is not the governor. So I would like for us to move slowly on this, to first go and find out what the clearly articulated state policy is in place now. And after determining what that policy is currently, to look at how it is supervised and implemented, and then see if we need to do this. I have serious doubts that we even need this bill, because I think our system works very well. I think we're well ahead of what North Carolina evidently was. But just would like, to request that we slow down on this and make sure that we're not undoing something that is already in good shape. Thank you.
Mr. Chairman, may I ask,
Please.
engage Representative Harden there?
Yes.
You served on a board, correct?
Yes, sir.
I want to get my train of thought right here. Now, Representative Dudgeon said his concern is we've got too many boards and too much regulation on business. Being a former board member yourself, is that a concern of yours of having too much regulation? I hear you talking about the jobs, and I'm trying to find out.
I don't think we've got too much regulation. No, quite
don't
frankly,
have too
I
much
think that these industries need to be regulated, and particularly when I was on, it was a healthcare industry, and it does need regulation.
Okay.
But because we've got to protect the safety of the public,
Sure.
and in our case, the health. But no, that's something for the study, perhaps. If we do a study on this, do we need 40 boards? My opinion would be that we do need the boards we have, and they operate, I think, pretty efficiently. I've not been in it a long time, but I believe those boards do a good job.
Okay. I think me and you are spurning some more thought and question here, but I want to make sure I stay clear on your concerns and comments out of respect. The moving slowly part, I think, is what we're doing here. Chairman Epps said we're not taking a vote today. We're here to hear concerns and vet out and see what we need to do to make this bill better, again, to protect Georgia. And quite frankly, if the will of the General Assembly says we want to take our risk and go into federal court, then that's the will of the General Assembly. But I want to make sure I follow it right as I try to handle this piece of legislation for the governor's office and Secretary of State and Attorney General. I'm hearing Representative Dudgeon worry about too much regulation, and you're saying we like the regulation, and I'm thinking too much regulation hurts jobs from expanding and growing, but you're worried about not enough regulation holding jobs back?
No, you didn't hear me say I was worried about too much regulation. I said that I was not concerned with the amount of regulation that's in place now. I don't know that much about it. And as far as moving slowly, I'm not talking about just having one or more hearings on this bill. I'm talking about establishing what is in place now, what needs to be changed, and how much needs to be changed. I'm not talking about the bill moving slowly. I'm talking about we probably should do some background work on this before we even consider the bill.
Okay. To help me again, if I may, Mr. Chairman, I want to make sure I'm on Mr. Harden's, Representative Hart. Is that okay?
Okay.
The job specific, I want to make sure that we're not handling something that's going to hurt jobs. And I know you mentioned that, and I was tying it to Representative Dudgeon talking about too much regulation. Where does the jobs concern come in there?
Well, what I'm saying here is if we put someone in charge of all of this who is not an elected official and who is not basically maybe a permanent employee, as an appointee, a designee, as time goes on, could change from time to time, that bothers me, and that they might, to put it bluntly, they might mess up a system that's working pretty well right now.
Okay.
And that's why I want us to make sure that we move slowly enough to see what the system needs before we go about trying to redo the system.
Okay, and I got one more. He's getting my old hamster's turning there, Mr. Chairman, so bear with me. Having been a former board member, I know you referenced the Attorney General now sits in and gives counsel to the boards as they're trying to make decisions on regulation. What happens it may never happen, but what happens if the board doesn't take the counsel of the AG sitting in, either in person or via teleconference, into a board meeting? If the board decides not to adhere to the counsel, where's the safety net then?
All right. And it has been a long time ago, but when I was there, we took the Attorney General's recommendation because we were told if you do not, then the state does not protect you.
Okay.
It's a simple issue. There's no problem answering that.
Okay. Back to the job part and regulation, I think to Representative Dudgeon's point and to yours, I think if I could find a common denominator there would be that I think I've heard the will consistently from a lot of people that is there some way we could study how these boards are handling existing business and the regulatory manners that go into how they function on a day-to-day basis currently? I can't sit here and tell you yes to that. I think that's up to the will of the body. And it sounds like what I'm hearing is from you two and from others that may be something that's looked at. I would go back to, until then, what do we do to make sure that we don't wind up in a court case? And so that's what I'm here about today, Representative Harden.
All right, and I think that's what I started off with. I believe that the Secretary of State could probably catch up very quickly, and the Attorney General, on how the system is operating as far as active supervision. I think we probably will find we've got active supervision. I'd be surprised if we don't, but that can be done very quickly by looking at what supervision is still in effect. The other part of it, the clearly articulated state policy, also would be a very simple issue to go to. Look at the state policy, see if there are some changes made. But changes to a state policy are much easier to make than writing a new bill to create a new department and with new oversight and some that is questionable. So if, all I'm saying is let's find out what we've got before we start creating a new being, I guess,
yes,
new
sir.
entity.
Yes, sir. And I want to, again, Mr. Chairman, one last thing, and this committee at large and everybody in the room, this piece of legislation comes from the Attorney General's office, Secretary of State's office, and the General Counsel of the Governor's office. So I think they've tried to put their heads together and say, okay, guys, what do we do? And to get into the details and the legalese side of it, Representative Harden, I can't do that. You know that. And I think everybody on this committee knows I can't do that. But I think they've done that to a certain extent, and this is what they've come up with as a simple solution for now. And whether the will of the Assembly is to go on and study further, then, like I said, that's up to the body.
Yeah, and I think, if they've done this studying, if they know what we need, and if they have identified some things, then I think that should be a part and package of the bill. As they should have informed you as to, if you're going to present the bill, what is in place, what needs to be done.
That's why I've got them all here.
All right.
So,
all right.
Listen, we got several more questions. Let's move forward.
okay. Thank you, Mr. Chairman.
Thank you, Mr. Representative Harden. Representative Henson.
Thank you very much, Mr. Chairman. Representative Nimmer, you've certainly been at a microphone a lot today.
Proud to be here.
I've worked with boards. I've been here for many years.
Yes, ma'am.
I've been on health for most of the years and also for economic development. At one time, I think every single board brought issues before one or two of those committees, so I've dealt with that. My concerns is turning it over to the governor's office.
Okay.
I think, and we're going back to one of my initial concerns is always turning too much power over to the executive branch. And this is not directed at any governor in specific, because I had this problem back when we had Democratic governors, and I still have this problem, and I've expressed this concern. We create new bureaucracies, and we also don't have a fiscal note. There would have to be people hired and brought in if we were doing it. Currently, as I understand it, there's oversight by the AG's office, and someone is there. So I wonder why we don't continue using that system. Another grave concern that I have is, over the years, and I hear this repeatedly from the board, is how understaffed they are, how underfunded they are. This has been a major, major concern. They generate X amount of dollars, and they get back a much smaller amount in which to operate their offices. You get into many different areas. When you have renewals, it can be slow as slow can be. This would slow things down so much more if we kept it under the governor's office, as you're saying, because it's bringing in totally new entities. And I have a lot of concerns with people who have issues, problems before the board, people who might be sanctioned before the board, and things just dragging out, because not only is it now the board doing the oversight, we have to bring in another entity that has to approve or disapprove of what the board's doing. And are we taking away the power that we did give the board, which is we make the laws and we leave it up to the boards to promulgate the rules and regs? Are we now taking that away from them?
No, ma'am. They still have the ability to make rules and regulations, but if there's ever an appeal to that board, there's a way to do that and keep Georgia in a safety net through this mechanism to not get into a federal lawsuit. And on the time frame, you mentioned, does it slow down the time of a decision being made? Mr. Chairman, that was one of the concerns that was brought up. I've had the opportunity to talk to General Counsel out of the Governor's office, and I haven't had a chance to talk to Secretary of State's office yet, but that's one of the things we want to discuss today. What is the time frame? Do we put a limit to how long a decision has to be made out of this designee if there's an appeal to this Reform Act figurehead, if you will? So that was, I'm sorry?
Nothing.
So that has been brought up, Representative, and willing to listen and try to work through and accommodate a reasonable time frame. That way things aren't drug out. And if people have an appeal, they need a license done. If you're trying to open a business and you can't get it done fast enough, you've got somebody you can call and light a fire and get that license turned out quicker for an example. So
a follow-up question.
Sure.
Why does it have to be under the governor's office as opposed to the AGs? We currently have assistant AGs who do attend all the meetings with an expertise in the different areas of the board. If we put it under the governor's office, we have 40 boards, we're going to have to create or have 40 new people or people that are experts in their area. But they also, in a way, would need to be lawyers in order to interpret everything. So it looks like we're creating a whole new department as opposed to using what is currently in place and having the AG's office as the designee. And not the designee, but having putting the AG's office in lieu of putting the governor's office. I don't see why it can't be done that way.
I think with the council of those three branches that helped craft this legislation, they looked at the involvement level that the Attorney General's office is already engaged in these regulatory boards, and I think they felt that person would still be engaged from the AG's office, but you would take a designee from the governor, and they would get counsel from them to give their opinion. But I don't think you would see 40 plus new designees come out, one for each board. I don't believe that would be the case.
Okay, I exaggerated some on the 40, but you would need new people to come in.
I definitely don't think 40, but
however many
somebody's going to have to do it.
How
Yes,
many
ma'am.
assistant AGs you have covering the boards? And I don't know the number of AGs that are currently needed to cover the boards. You would need the same number out of the governor's office if you continued under this.
I respectfully disagree with you, Representative. I believe what you would see is the AG giving that counsel out of the board, whatever the board was debating or trying to make a decision on for rule or regulation at that point, communicating with that designee. If it's 10 out of the AG's office, communicating back and having that conversation with maybe one designee out of the governor's office. You can.
And
yes,
I do
ma'am.
disagree. I don't think
ma'am.
one person could adequately cover 40 boards.
I would hope that we wouldn't have that many cases going to this person. I would hope that the boards are functioning in a manner that they're handling everything on their level and there's not that many appeals coming to it. Again, this is a measure of a safety net to keep us out of litigation and to solve problems. And I believe you see the boards doing a tremendous job in Georgia as it is. Whether you agree with the amount of regulation or not, I know that's debatable among everyone, and the number of boards for that matter, Representative Dudgeon, but they're doing a good job now. I think this gives us that ability for the AG sitting in person or via teleconference to those meetings to correspond with that designee and say that we've got this mechanism in place. So.
But I want to bring you back to line 50. Review and in writing, approve or veto any rule. So that means every single thing. It could just be the fact of infractions that the folks that are licensed. It could be rules that are being promulgated. It could be so many different things. I don't believe one person could adequately handle the number. I would like to see it stay under the AG's office. Again, I'll go back to one of my major issues, which is putting too much more under the executive branch to a point where I'm not sure what we need the legislative branch for.
Thank
Thank
you. We have other questions. We need to, thank you, Representative Henson. Representative Breakstrom.
Thank you, Mr. Chair. So I want to echo what Representative Dudgeon said, that I do think we need to look and streamline and try to look at, how these boards are operating. I know that there has been an effort to expedite licensing so that people aren't waiting, months on end. I think we need to be looking at reciprocity between the states. I do have a concern with unelected bodies creating rules, because we're the ones that are going to get the calls when there are things that are going on. And I think if the purpose of these boards is to protect public safety, then we wouldn't have issues like, let me give an example. All of the fines that have been levied in the cosmetology field for people that have hair that wasn't swept up in their salons, that's been very costly for salon owners, and that is really not a public safety issue. That to me is a consumer issue. If the salon they go to has hair on the floor and the consumer doesn't like it, they should pick a different salon, and not something where government should be intervening. And so, based on some personal experience, though, with licensing and reciprocity among the states, I've had some issues that I have taken to, like, the Secretary of State's office, and they have said, we don't really have the ability to overturn or change some of the decisions that these boards are making. So, I do think that we need a streamlined process, but I don't know that putting another layer of bureaucracy on a layer of bureaucracy is the solution. And then someone mentioned that we have, there may be an amendment coming out where there's going to be legislative oversight rather than putting it in the executive branch, or is that the case?
That's why we're here today. I don't know, Representative. But Mr. Chairman,
So one more thing.
Sure.
So, and I have to agree with Representative Harden that I do think we need to go slowly and methodically through how are we operating, where can we streamline, how can we make this an effective process where people can come into our state and do business, get their license, not feel like they're being harassed by a board, for having hair on the floor or whatever. There's 40 boards, so I'm sure there's other issues in other. That's just one I'm personally familiar with, and so. I do like the idea of kind of stepping back and taking a comprehensive look at all of it and coming up with a streamlined approach with some level of oversight, because if you do have a situation and there's a boneheaded decision being made, which happens, believe it or not, it is nice to be able to say, somebody can call and go, okay guys, what are you doing, but as it stands now, my understanding is, like, the Secretary of State doesn't even have the ability to override or influence. I guess they can influence and say, guys, what are you doing? But it shouldn't come to them, calling their representative and us having to call the Secretary of State. I think that, but giving them the authority to do rulemaking, I think, is even more problematic, because then you get more red tape and bureaucracy. And so, anyway.
So
go ahead. That's all I wanted to say.
Please. Go ahead.
Mr. Chairman.
Sure.
So, Representative Rakestraw, I think you kind of built the point of where we are. Speaking to cosmetology, I've had constituent calls where a salon owner decided to start selling flip-flops and T-shirts in her salon, and somebody comes in and writes them a citation or whatever, a fine of $1,000 or whatever it may be. Mm-hmm. They have nowhere to appeal that to right now, and which was your point. This gives them someone to call and say, I disagree with this. Can you look into it? Mm-hmm. Right now, when you and I get that call from our constituents, and the lady that's run this hair salon down on the corner for 40 years, all of a sudden gets a $1,000 fine, and she's not going to pay her rent that month. This gives them an avenue, to my understanding, to have someone to call with authority.
Right, but before we get to that point of having to call someone to overturn a decision, how did they get to that point of that much, overreach?
I think you and Representative Dudgeon are linking up here on the amount of regulatory issues, which is not what this bill is about. This bill is to get us in a point where we don't end up in federal court. The will of the body can go out and develop a study committee, as everyone well knows, and decide what do we need to do with boards. How do we need to view them? Is it a true, if you go into a restaurant, that's one thing. You're dealing with somebody cooking meat and preparing a meal for you. If I go into a barber shop or a hair salon and I decide I want to sit down in a dirty one, that's a personal decision. I can't see what's going on in the kitchen. So, you know, and I understand what Representative Dudgeon said. I've had numerous members come up over the past couple of days expressing these concerns to me. But again, this bill doesn't touch that. If that's what the will of the body is, then I would say the body needs to move forward with that motion. What this is, out of the AG, the Secretary of State, and the Governor's office, is, hey, we need to put something in a placeholder to give us a protective measure until everything else is resolved. So but your point is well taken.
I agree with bringing us into compliance so that we're not exposed legally on that situation, but I don't know that, I mean, were there alternative ideas suggested outside of giving it to the
I went in,
executive branch to
Representative Rakestraw went in with a lot of wisdom and influence over those three heads that were sitting around the table, and this is what we came out with, if that tells you. So this has been well vetted between those who were in the business of counseling the boards, sitting in on those meetings, the executive branch, the Secretary of State's office, that are all the ones getting called, and the executive branch is brought in from the legal side and the Secretary of State side going, this is the fit that we see for now.
Mm-hmm. Okay, thank you.
Thank you,
ma'am.
Representative.
Thank you. Good question.
Representative Sharper.
Thank you, Chairman. Well, I like the dialogue that we're having right now.
That's wonderful.
But what I'm seeing, we may have to look at some type of study committee, and it seems like the boards and all these things that we're doing are what the people call all over the place, and we need to kind of mainstream it so we don't just rush into something and just look at the big picture, and so that once we do get something together, then it can move forward through the entire state, dealing with the boards and everything. That way we don't have to keep coming back. Once we do something, then it's not complete, then come back again. So we really need to take the time to put together a good study committee and just take all these concerns, put them together, and come up with some type of ironclad situation that's a win-win.
Thank you,
This is my
Representative Sharper. I'm hearing the message, but again, that's not what this bill addresses.
Okay.
I think that is up to the will of the body. Maybe this committee can actually be the genesis of where that begins. That's totally up to you guys, Mr. Chairman. But this bill addresses where the posture of the state is now.
Okay.
It would not prohibit doing any further studies or changes to boards. This fixes us where we are now. If you took it down to one board in the state of Georgia, you would still need some safety net of an appeal process. So,
Okay.
well said, though.
Well, just a follow-up quickly.
Please, go ahead.
Now, what's the biggest concern on the other side of this? You say you was talking to other people, in passing, but is there somebody here specifically that's going to speak? Okay.
Well, let me look at, apparently we've got about 4 people signed up. That's the chairman will call them shortly.
Okay.
I'm sure they'll come up and express their
Their
input.
Okay.
All right. Thank you, Representative Sharper. Any further questions from the committee? Comments? Thank you, Representative Nimmer. Did a great job.
Thank you.
We will, if no one has any further questions of Representative Nimmer, we will, at this time, let those that are attending that have a desire to speak come and address us. And Leo has the list. Our first signee is Mr. Aubrey. Thank you. You just state your name and who
Yes,
you
sir.
represent. And
Thank you, Mr. Chairman. I'm Aubrey Valines. I represent the Georgia Optometric Association and the Georgia Chiropractic Association. And some of the other associations I represent, I think, are going to follow me as well. I want to first thank Representative Nimmer, the Governor's office, Secretary of State's office, and you, the Chairman, for meeting with me to discuss this important issue. And I want to address some of the questions that were asked. The North Carolina law and decision is very different than Georgia. North Carolina issued a cease and desist order to a group in the mall, they didn't have the power to issue a cease and desist order. They issued it based upon they were doing whitening. Whitening was not in the scope of dentistry. Removing stains was. So bad cases make bad laws. North Carolina is very different. The Supreme Court also cited what the two of you spoke about, the proliferation of boards causing too many rules and too many journeys into antitrust violations. I want to talk about two things in this bill that haven't been talked about. If you'll turn to page 3 and look at line 58, so you'll know this is not about just rules. Review and in writing approve, remand, modify, or reverse any action. Any action. And then the second part, A and B, which I guess modifies 3, talks about challenge via an appeal to the governor. So basically, they could appeal any action the board does, not just a rule, any action. So you're making the boards not even a figurehead. You're making them useless. It's not even rules. Anything they do, any action, they can appeal to the governor. I like this governor. I really do. Right now, I have the right. I've represented hundreds of people in front of I can't tell you how many boards. And I've taken it all the way to the Supreme Court. And right now, if I don't like the decision the ALJ has or whoever, I can take it by certiorari to the Superior Court. I don't know if this is taking away my rights to the court, to certiorari, but right now it's an appeal to the governor. But I want to point out it's any action. You've heard, has there been any other suggestions? There's a couple of suggestions. The Supreme Court did not mandate the model you have in front of you. They did not say you have to have the governor. In fact, the FTC actually said in their guidelines, which I've given a copy to the committee, I'll be happy to share more, they said, does not require that a state legislature provide for active supervision of any state regulatory board. A state legislature may and generally should prefer that a regulatory board be subject to the requirements of antitrust. So they tell you don't have to do anything if you don't want to. But I tell you don't need any more laws. Right now, in every board meeting you have, an assistant attorney general sits there when they promulgate a rule or a regulation or suggest it, and you get advice from that person. Every time I take a client in, there's a complaint and something they're charged with, there's an assistant attorney general sitting right there. When I go to a hearing and they prosecute it, there's an assistant attorney general prosecuting it. The assistant attorney general and the attorney general's office is involved in this process all the way through. Why now do you want to say, we don't need you, we're going to bring the governor in? And they will tell you, as you said, if you don't follow our advice and you get sued, we can't protect you and can't defend you. I can't tell you how many times I've heard that. Now, better than that, if you look at 50-13-4, this is the administrative oversight procedure for these boards. And right now, if there is a board promulgated, a rule promulgated, you don't have that in front of you, I apologize. It goes back to the chairman of the standing committee of which it would go to if it was introduced as a law. What a great oversight. It comes back to the legislature, and the legislature can object to it in a very, very cumbersome process requiring 2/3 votes and all kinds of things. I have simplified that by striking F1 and F2 of this law and basically saying that the legislative oversight committee, which would be the chair and the committee, would also have the power to remand or veto. That makes sense. Right now you have the power to object, and then it goes to the floor of the House or the floor of the Senate into a lengthy process, and then ultimately to the governor. Simplified that very quickly. You don't need a new law. Give you the right to veto it. Give you the right to veto it. Because you're the one that would be making it as a law if the rule brought to you as legislation. There are all kinds of procedures that we think would be better than doing it this way. In the past, it's sometimes taking us 2 years to get an appointment to the board when there was a vacancy. What's going to happen when it's a rule? And it's going to politicize this process unbelievably. The dental hygienists are going to run down on the dentist. The MDs are going to run down to the pharmacists, the ophthalmologists on the chiropractors, the engineers on the architects. I can't imagine what a nightmare this is going to be. Again, I'm very familiar with the court decision. I've lectured on it. I'm very familiar with it. And I can tell you what it does mandate and what it doesn't mandate. It talks about active supervision. And yes, this is a way to ensure active supervision. There are easier ways without making new laws, and that's simply going to 50-13-4 and striking 2 paragraphs of law, removing law, and giving you the power to veto. That's fine. Or if you don't like that, the AG's office, who is sitting in there in every meeting, why shouldn't they have the veto power? I'll be happy to answer any questions you have about the decision or about our proposals. And I have a couple of amendments if my assistant would pass them out. And let me tell you what these do. One sets a 90-day submission. If a rule is submitted to the governor, he has to act on it within 90 days. Approve, veto, remand, whatever, within 90 days. The second, as you have heard, this is to make sure that they're in compliance with the active supervision, so they're not in violation of antitrust or in violation of the North Carolina Dental Board examiners versus FTC. The second amendment on that page said you can amend, renew, veto any rule that is anti-competitive or violation of antitrust or this decision. It doesn't give them the right to veto rules that are outside, because what we're talking about is this antitrust decision. If we're not, we need to know. This committee needs to know otherwise if there's more being talked about. But again, I want you to understand, this says any action, not just any rule. Thank you, Mr. Chairman.
We do have a question.
Yes, sir.
Representative Rakestraw.
Thank you, Mr. Chair. So this amendment is basically with the existing bill. Do you have an amendment that does what you're speaking of in striking the code that would streamline? Because I like that idea. And I mean, I definitely want to protect ourselves from, whatever happened in North Carolina.
If I could, that basically says within 60 days of submission of any rule or proposed action by a professional licensing board, the chairperson of the appropriate standing committee shall have the authority or duty to actively supervise the professional licensing board of the state to ensure their actions are consistent with clearly articulated state policy, straight from and shall therefore have the authority to remand, modify, reverse, which tracks the governor's language, or veto a proposed rule or action by the professional licensing board. That simply vests it with you. Now, what you're going to have to do, though, is you're going to have to strike probably sections F1 and F2 that's already in this code. There's nothing wrong with getting less law, because that process of F1 and F2 has to do with once the committee objects to it, then it has to go to a vote on the floor of the House or the Senate. And if the committee has the right to veto it, you don't need to go to the floor of the Senate or the House unless you choose you want to and leave that in there. But yes, that would do it.
So is this in terms of licensing, or is this in terms of infraction on a rule? I mean, what area are we speaking about? Because I wouldn't want to hold up anyone's licensing until we're in session, but I do like the idea.
Well, this is of any rule they promulgate. This is only with rules. It is my opinion that the other proposal, 952, goes beyond rules, because it says review and in writing, approve, amend, modify, or reverse any action. It doesn't say rule, but my proposal simply addresses rules.
And I agree with you that things can get very politicized and become ridiculous. So,
yes, ma'am.
We have another question. Representative Harden.
Yeah, thank you, Mr. Chairman. I'll make this quick. But as I understand it, then the administrative law process helps people who are targeted, basically, and have to answer to the board. Is that correct?
Yes, sir. That is true.
And so that you have that process in place to protect them. And when we're talking about promulgation of rules, of course, the boards have to have public hearings,
yes, sir,
advertise. They have to meet several different times, so that those wouldn't be. if you had to enact a rule, wait till the legislature was in session, that certainly wouldn't be a major problem.
No,
but I believe we could do a process where those rules could be enacted and have an oversight committee maybe.
You have that process already now, except you don't have the veto power in that process. You have a process where it has to be voted on the House or the Senate. This would give you a veto power.
All right, good.
And one other thing I would add that hasn't been brought up, Code Section 50-13-10, again, different from North Carolina, gives you the right of what is called a declaratory judgment. Any petitioner, anybody aggrieved down below by a decision of the board, unlike the North Carolina situation, can take it to Superior Court and say, they did me wrong. It was anti-competitive. They're picking on me. And so I ask you to tell me what this says. This is really kind of a nice thing we have in our code. They can seek judgment against what the board did by declaratory judgment in Superior Court already. You don't need this.
Thank you.
Thank you, Mr. Chairman.
Any further questions? Thank you. As a point of information, we'll ask Legislative Council members to look at this and make sure we have an accurate picture of the statutory standing of this. And
you said would need to be struck in tandem with this? You have those notes.
Legislative Council does have that, and they'll review that and just give us an opinion. Sure.
Thank you, Mr. Chairman. I know you're in the middle of calling up those who have signed up. Just real quick, a couple things that popped into my mind. On line 58, Mr. Aubrey pointed out the word any. Where'd Mr. Aubrey go? Yes, sir. Right here. I appreciate. He came by. I want everybody to know he's not in here ambushing me by any means of the legislation. He came by and talked to me before. However, this isn't the one word we talked about. But so I just wanted to point out. Listen to what we're trying to do, and we've gotten totally away from the conversation of regulation. And now all of a sudden we're talking about we all have power. Line 58 says review and in writing approve, remand, modify, or reverse any action by a professional licensing board, that is, and it goes under. Well, folks, that's what this is about. If they do something wrong, Representative Rakestraw, to the point of the cosmetologist, if anything is done wrong against them, they need the ability to have somebody to appeal to besides the federal court. So the word any, I don't see a problem with that. The AG is there to give counsel, not opinion and recommendation and veto power. The AG's office, and my understanding of their involvement with these boards right now, is for general counsel, legal counsel, not opinions, not bias, not professional. Here it is, boots on the ground. And again, I think we're okay with the 90-day thing. We talked about that, Aubrey and I did. There's no problem, and that's why we're here doing this process slowly and methodically, thinking through it. If we need a 90-day time frame in there for a rule to come out, and so that board appointments aren't left vacant for 2 years, and decisions that have been appealed to this designee aren't sitting held in some mythical jar somewhere, that hey, in 90 days you got to give us your opinion. And again, we just rapidly left what I heard was the number one concern here, and that's red tape on business. So I just want us to stay focused on what we're talking about. Thank you for the time, Mr. Chairman.
Thank you, Representative. Representative Stovall.
Yeah, one of my concerns, not just kind of going through the legislation, is when I hear the opportunity for, if someone had a disgruntled with the ruling, is having to go before the courts. When you're a small business, you can't afford to be going before the courts, and you want to be able to have a ruling or your issues dealt with, because the more time you're taking with getting that issue dealt with, it's costing you money. So I just wanted to make that comment.
Thank you. Thank you. All right, our next speaker is Mr. Bob Schmidt. If you will identify yourself, please, sir.
You got it. Good afternoon, Mr. Chairman and members of the committee. I'm Bob Schmidt. I'm here on behalf of the Robert Shields Memorial and Monument Company. It's a Cobb County-based business, and we were looking at this bill, and we really want to support and do support Floor Leader Nimmer's bill, and thank the Governor's office, the Secretary of State, and the AG's office for working on this. It's critically important that we look at what power these boards have and how much they have, and frankly, how they're made up. A lot of these boards, and I'll use a board called the Cemetery Board, has 6 members, 5 of which are cemeterians, 1 of which is a layperson. Well, obviously, those votes go one way or the other often. That one sole vote of an individual probably doesn't carry much weight. So we'd ask you to look at that in addition to what Representative Nimmer and the AG's office, Governor, and like are trying to do. We fully support the effort. We think it's a great idea. As far as how you do the oversight part of this, that's up to you guys, okay? We could go either direction, whether it's the Governor's office or the legislature or what. We just think somebody needs to really be having oversight.
Right,
so thank you.
Any questions, Mr. Smith? Appear to have none. Thank you, sir. Mr. Tom Bauer.
Thank you, Mr. Chairman, members of the committee. I'll try to be brief. Aubrey Villines covered a lot of my points, as have actually several of the committee members. And I did also speak with Representative Nimmer briefly yesterday, so this is not an ambush. I did express some concerns to him, and I want to thank him because he said he was open to ideas. I wanted to comment on a couple of things. I think the focus has gotten away from, and Aubrey's right and Representative Hardin is right. This is very different from the North Carolina case. The North Carolina case, you basically had folks who were nominated by the Dental Association and then who were making judgments on the scope of practice because there was nothing about whitening of teeth in the code. And the way we do it in Georgia is, I know you guys get tired of wearing your referees hats and stripes, but you fight a lot about scope of practice and what's in there. So we've already got that, and it's not been turned over. But the focus of this decision was dealing with competition and anti-competition, and the fact that a profession was basically defining what it was, and then basically putting somebody out of business on the whitening of teeth. The focus of this ought to be on the anti-competition, so I would offer that to you. I would respectfully also, I think this bill is well-intentioned, but it does give the governor the authority and the duty to look at every rule and every action, because it says to look at rules that are submitted, and I think Representative Henson, actually, you pointed it out on line 50 when you said any rule, but after the word any rule, it is before it is filed in the office. So it's basically everything that's coming out, all the boards that you're asking the governor to look at. The only other thing I would mention is that I think this also, you need to be careful that you get away from areas of expertise. The Secretary of State had a well-intentioned piece of legislation a couple of years ago where he wanted, and he was concerned about jobs, and he wanted to speed up the application process, and he had, for lack of a better term, a super board, which did not necessarily have the expertise of an engineer on it for an engineering decision, or an ophthalmologist for a medical decision. And I do think right now, and Representative Hardin's right, the way the system's working, and Aubrey's right, the attorney generals are there with the boards, and they are making very active advice and giving that advice. And I can tell you, the hat I'm wearing today is the Occupational Therapy Association, but I also represent the PAs. And there have been some times I'm not happy with the AG's office when I'm following things at the medical board, so I can assure you that the Attorney General does have an active involvement in that, and these folks work with these boards on an ongoing basis, so they do have expertise. So I would urge you to look at this very carefully. There does need to be something that needs to be fixed, but I think we need to do it in a very narrow fashion, deal with the competitive aspect of it, and not create a whole other level of government, if you will, that doesn't necessarily even have the expertise there, although I do think this is well-intentioned.
Okay.
Thank you.
Thank you. Any questions, Mr. Bauer? All right. Thank you, Mr. Bauer. And the last signee we have is Carrie Johnson. Carl, excuse me.
Mr. Chairman, members of the committee. Thank you very much for being willing to hear my comments. I am the legislative chair for the Georgia Association for Marriage and Family Therapy, but I'm really speaking to you today because I served on a state licensing board for 8 years, the Georgia Composite Board of Professional Counselors, Social Workers, and Marriage and Family Therapists. And I'm really speaking from my experience as a board member. And it's interesting, my thoughts are entirely consistent with what Representative Hardin had to say. I guess having served on a board, you learn a lot about this whole process. Regarding subparagraphs 1 and 2 on lines 50 and 54, it's already been said over and over again. And I'm not a lawyer. I'm not an expert in this. But when I was on the board, it was very clear that the Assistant Attorney General was there, that they reviewed every rule that we drafted and gave us the exact kind of oversight that it seems to me, is here being asked of the governor's office to do. But the thing I want to speak to you particularly about is subparagraph 3, line 58. It says, review and in writing approve, remand, modify, or reverse any action by a professional licensing board that is challenged via an appeal to the governor. In the 8 years I served on the board, only twice did it happen that an elected official attempted to intervene in a decision of the board. There were both occasions where we denied a credential to somebody. In one case, a license, in the other case, an approved supervisor credential. Approved supervisors are the people authorized to train prospective licensees. I was on the board. I knew in both those cases that one person did not get the license and the other person did not get the approved supervisor credential because they did not qualify. I learned something from this experience. In fact, there is a whole process for people who believe that the board has acted unfairly with them. We were told all in all that they can. If what happens really is the assistant AG normally negotiates a consent decree when there's a discipline issue, and if the licensee doesn't like that, they can go to a hearing, and then they can appeal the result of the hearing. If somebody doesn't like if they're denied a license, they can appeal that. There is already, we were told over to the board that the licensees, we have to afford them due process. They have various recourses in due process already. The people who had legitimate concerns took advantage of that due process. The people who were denied a license and who were unjustly treated by the board, they went through the existing due process system. The two people who went to a elected official to intervene were people who didn't have any legitimate case. These were people who had a political connection, and they tried to get their political connection to intervene on their behalf. I'm going to say those 2 times in 8 years was a very disturbing process to me. One of those times we stood up to the elected official who attempted to intervene, and we said, no, this person is denied a license legitimately. The other time, the elected official had so much power that we were forced to do what they said. We had to give somebody a credential that I knew they weren't qualified for. It made me sick to my stomach. I had trouble sleeping. It was an awful experience. I'm afraid when I read this here, when it says, review and in writing, approve, remand, modify, reverse any action by a professional board that is challenged via an appeal to the governor, I'm afraid this will become a magnet for funneling the very kinds of concerns. People who have a legitimate concern go through the existing due process, appeals and hearings. It's the people who don't have a legitimate concern who might, in fact, try to go through appeal to the governor, go to an elected official. Essentially, people who want to use political connections to get what they want when they don't have a legitimate case, which would get fair hearing in the normal due process. So I'm very concerned about this. I think this reviewing any action where anybody brings an appeal to the governor could become a magnet for just those kinds of cases that I had to deal with 2 of on the state licensing board. Thank you.
Thank you. Any questions? Anyone? Okay. Representative Hardin.
Representative, could I ask one other thing? Just if if it's possible to get this information. We say we have 40 boards. Is that correct?
40 plus.
40
Mr.
plus.
Chairman, may I reference
And
Secretary of State's office?
That's all right. The number's not important. What I was saying is we can easily get a list of those boards and know what.
I can get you an answer right now
Well,
if you got the question.
Well, but maybe you can, maybe you can't, because a professional licensing board over which this one person has the ability to review any challenge. Professional licensing board means any board, bureau, commission, or other agency of the executive branch of state government. So what I was going to ask is, can we get a list of Secretary of State's boards are easy to get, but I wonder how many bureaus, commissions, or other agencies are out there that
Sure.
This is going to affect.
Sure, absolutely. That's what we're here for, again, moving through this process,
All right.
hearing only, no votes, to get all questions answered and concerns resolved, hopefully. So I'll get that information for you. But, Mr. Chairman, if I may, I just want to address a couple of things. This does not exclude the Attorney General's office from being engaged in general counsel in any board meetings. I don't know that anybody believes that, or no one has come up and said that, but we keep talking about that the AG's office is already there. This does not remove them in any way, shape, form, or fashion. So they're there. This gives a process for an appeal to someone that's not giving general counsel unbiasedly to a board, which brings up the concern of the last gentleman. Does political power come into play here? I'm not that superpower elected official that he referenced. I don't think any of us tout ourselves for being that. And the move of this legislation is not to have anyone lose sleep. And I regret, and I applaud him for 8 years of service on the board, and I regret that he ever had to be in any decision-making process or doing something that was against his better judgment that caused him to lose sleep, or for that matter, any board that's ever been put in that position. Legal opinions differ. That's why we have courts, that's why we have lawyers, that's why we have defense attorneys and plaintiff attorneys and so forth and so on. That's why we have this bill. You can get some opinion that we're fine the way we are. You can get some opinion that says we need this. Look, if you tell me, Chad, you need to tie your shoes or you're going to trip, or you can leave them unlaced and you might not, I'm going to tie my shoes. I'm not going to take the chance of getting myself hurt, and this is a bill that does not take a chance of getting Georgia hurt in court. Now, the concerns have been heard, and I just want to express my passion about this, that I believe it's with a good intent of the state of Georgia and the 40-plus boards, and Representative Harden, I'll get the list of anybody else that's there, however big that list is, to give a protective measure, and I wish Representative Rakestraw was still here, to protect that cosmetologist or that barber or that builder or licensed or pharmacist, whomever it may be. Right now, if you call the AG's office, they cannot overturn a rule. If you call the board, they don't have to. If you call the governor's office, sorry, can't help you. Call the Secretary of State, no answers. This gives a process. We're just minutes away from somebody discovering that there is a way to get in the court system and win before the state of Georgia is in a court hearing. That's all this does. I understand the fear, and it's a legitimate concern. But the unknown is what we deal with up here. Everything we do in this body deals with an unknown of what the laws are that we're going to pass. But we go in good faith and move forward to do progress and good measures for the safety and welfare of the citizens of this state. I think this is one of these measures that does that. Mr. Chairman, I'll be glad if you want me to take any more questions. I'll be happy to. I don't know that I can say any more that's been said or give any more opinions that's been given up here, but I just want to make sure that we're clear that you can get multiple lawyers up here, and according to who it is and how they read something and dissect it, you're going to get multiple opinions. That's why we have this, to try to clean that up, whether we need it or not. I'm a logger, not a lawyer.
Thank you, Representative, and I don't see any more questions, so we appreciate your willingness to share this with us and to
absolutely, Mr. Chairman. I look forward to our next
address
committee
all these
here.
concerns. And does anyone in attendance have anything to say that we? If not, then we'll we'll have another meeting next week, at which time, if you see the need to try to address any of these concerns, I'll leave that to you. If we'll move forward with where we are, it's just we'll get a meeting next week's our last week, so we need to.
Yes, sir. Mr. Chairman, room 113 at the Capitol. Anybody? Please come by. Let's sit down and work through any concerns you may have. Thank you, Mr. Chairman.
Thank you, Representative. We appreciate you coming. We appreciate the input from all concerned, and if you have any, please address them to him.